Hi, my name is Lee Morin, and I am the principal and founder of Morin Legal, a small business and entertainment legal practice located on the East Side Beltline Trail in Atlanta, Georgia. And today I want to welcome you to our LinkedIn Live discussion. Today we'll be talking about article that we wrote earlier this year in our newsletter in July called The Office's Dunder Mifflin Case. So feel welcome to explore our blog after this concludes for details, including a copy of a couple of the court papers we'll be referencing in this brief discussion where I, Lee Morin, will be giving you my unbridled opinion on some of the reading between the lines matters that you might not pick up when reading the public record, as I have. So without further ado, let's jump in. So what in the world is Dunder Mifflin, you might ask? Well, if you are a fan of The Office, you might immediately know that Dunder Mifflin is the name of the paper company that is featured as the location, the setting for the drama that happens in The Office. And what is The Office, for those who don't know, is a US production that is actually based on a UK production originating in 2003 with Ricky Gervais, comedian, and starting in 2005 with comedian Steve Carell in the United States. It ran for 9 seasons, was widely successful. And so Dunder Mifflin naturally grew popular as a result of fans watching the show. And what is that called in the world of entertainment when you're creating properties? Dunder Mifflin, the name of a universe or location, is more or less used by entertainment companies like NBC Universal to sell merchandise, which is a way that the fans can have some relatable connection to the shows that they love the most. And an analogy would be when you go to a concert and you buy a concert t-shirt, that is the epitome of merch because it's a t-shirt that has a relatable connection to your memory of experiencing that show. So naturally, NBC was producing merch as early as 2006, selling properties bearing the name Dunder Mifflin. So the first question that I ask when reviewing this entire fiasco, which is definitely a fiasco, is, why wait so long to register a property like Dunder Mifflin? Portfolios at large corporations like NBC Universal are probably in the thousands when it comes to trademark ownership. So if they had these priority rights that they're alleging, why wait so long to file for a registration? Indeed, they were unable to get a registration because this other party, the defendant in this case, has the registration. So why wait so long? And let's look at the complaint because I'm fascinated actually by this, having worked in the intellectual property law departments of large multinational corporations with huge portfolios. And some aspects of what they were doing was selling merch as early as 2007 in a physical store in New York. So, that's just one location. But then they created a website for the fictional paper company. So many people could interact with that. In addition, they've been selling merch through licensees. Indeed, one of the licensees, third-party licensees they sold to, received a cease and desist order from the defendant, which we'll get to later. And then, in addition, NBC Universal licensed a company to produce and distribute paper, actual paper, featuring the Dunder Mifflin branding and expanding the Dunder Mifflin and Office branded line to include other items like Sharpies, sticky notes, facial tissue, coffee cups, storage boxes, and legal pads. In other words, they were surely exploiting this mark to the maximum to achieve the most relatable merchandise they could for their fan base. So why wait so long to register the mark? In 2016, defendant came forward and filed their application for registration. And like I said, the office in the United States shot in 2005. So that's at least an 11-year gap. But, in the best defense, the law departments of large multinational corporations are often at neck and neck with the marketing departments, who sometimes are in healthy relationships and unhealthy relationships. I know that, having done many years myself, constantly there was marketing ideas that were unfortunately just not legally enforceable, and for one reason or another. So maybe there was a miscommunication possibly between marketing and legal, and the Dunder Mifflin trademark was never actually filed, which is unfortunate, because here we are today in court as a result, with a dispute from NBC Universal alleging their ownership rights, and the defendant, J. Connett Media Group, Gooder Labs, and Kenneth Talbert as an individual, defending their ownership rights, as it were. In the current timeline, we're still waiting on a response from the defendant. So all we really have to go forward on are the court records, which is the first complaint, and then the amended complaint. And really, the substantial differences between the two are that NBC added an additional intellectual property, from their show Friday Night Lights, regarding another property that they're alleging that defendant has been exploiting without proper authority, Dylan Football. So we proceed on this. Who dropped the ball on the registration? I suppose we'll never really know on the NBC side, but I'm sure that once this matter is cleared up, they can hopefully proceed with what they need to do to get that registration. And then the next question that I ask when I review these materials is, really, from the defendant's side, why poke a bear? Why and specifically, it's one thing to allegedly infringe on someone else's intellectual properties and manufacture products flying under the radar on Amazon or eBay or some other user-generated platform where people sell infringing merchandise all the time, right? Why not just live in that shadow space like so many other infringers do? But no, this particular person really takes it to another level, which in my opinion raises it to the level of trolling, which is in this complaint here we have information from the plaintiffs that says the defendant, in addition to sending cease and desist orders to their authorized third-party licensees to stop selling their own merchandise, in addition, hired an attorney to demand that NBC Universal pay a substantial sum of money to assign its registration. In other words, they were trying to leverage a lawsuit to sell their intellectual property to them, right? And certainly NBC didn't like that approach. How dare they try to sell us our own intellectual property? But it was the hubris with which it takes to hire an attorney and then demand a sum to assign the ownership rights in the Dunder Mifflin mark to NBC Universal, within the same communication, threatening to seek to have all of NBCU's and its licensees listing for merchandise bearing the Dunder Mifflin marks taken down from all distribution platforms, including Amazon. So it does take a lot of hubris to make that offer and to basically shut someone down if they don't buy their own mark from you. So that is that extortion, in other words, extracting for sale the money for this mark certainly was poking the bear. I wouldn't say any otherwise. And as a result, the bear fought back. And so NBC Universal filed this case. Furthermore, I'd say one more thing I'd like to add in the complaint is that J. Connett Media, Gooder Labs, and Ken Talbert, who allegedly is the sole acting party on behalf of both companies, which is why he's joined as an individual as well, even after making all of those threats to NBC Universal, if they didn't buy the rights to this registration, He demanded that NBCU enter into a consent agreement that would have given them substantive rights in these marks to which he is allegedly not entitled. So in a way, acknowledging the other side's rights in the mark. So in no way did any of this really help the defendant. And here we are waiting on defendant's response today. So that'll eventually file, I believe, in this very month of October. And hopefully we'll get some more information on that. Whether or not there's anything to report remains to be seen. Parties may settle out. Often happens in situations like this. We'll see what happens. Time will tell. Meanwhile, I just want to thank you so much for coming to our live event, and you'll be happy to know there is a second live event where we will once again be discussing a case involving trademark infringement. Seems to be the theme this month of October. If you liked what you heard today, go to our blog on Trademark Trolls Have Tolls, and it explains a little bit more in detail about this case, and we'll also have a copy of the complaints for your spare reading. Thanks again. My name is Lee Morin, and you have been a member of my LinkedIn Live.